Hello, everyone, and welcome to another live stream session with immigrationquestion.com, where we break down U.S. immigration in real time with the help of trusted legal professionals. We're thrilled to have you with us today. Today's topic is a game changer for anyone trying to work in the U.S. or support their employees through the immigration process. Work visas in 2025. What you're not being told about H-1Bs, TN, and L-1 options. The US visa requirements continue to change. The H-1B lottery is more competitive than ever. TN visas are facing increased scrutiny, while N-1 visas remain a great option for international companies. The requirements can be challenging, especially for new office setups and workers moving to the US. So, what do you need to know about immigration pathways in 2025 to succeed? That is what we are diving into today, and we have brought in a professional who lives and breathes this stuff. Joining us today is attorney Meagan Kirchner, founder and principal attorney at Kirchner Law in the greater Charlottesville area. With nearly 10 years of experience in U.S. immigration law, Attorney Kirchner helps individuals and employers cut through the red tape and achieve real results. She handles complex H-1B, TN, and L-1 visa cases, along with high-stake categories like O-1, EB-1A, and national interest waivers. Her approach, practical and result-driven, and focused on helping professionals and businesses achieve their U.S. immigration goals. Welcome to the show, Attorney Meagan Kirchner. We're glad to have you here.
I'm happy to be here. Thanks for having me.
Thank you. Great. Let's jump right in. To everyone watching across platforms, please take out your notepads and pens because we're going to get into the details now. Attorney Kirchner, let's start with the TN visa.
Sure.
What are the most common challenges applicants face when applying for TN visas, and how can they avoid them?
So for TN visas, it tends to be a little more of a streamlined process. For obviously for foreign nationals from Canada or Mexico, and the biggest issue that a lot of workers will face is, issues related to the employment letter, vague job descriptions, including duties that are wholly unrelated to the TN occupation that they're applying for. So anything related to the job description that, deviates from what the officer would expect to see for that occupation category can cause confusion. It can, the officer will be unsure on whether you're actually applying for a job that meets the requirements that falls into a specified occupation if the job description is not well written and clearly fitting the intended occupation. Another huge red flag that can make or break your application is if your package doesn't include any employer contact information. So if the officer needs to call to verify any information on the spot, they're not able to do so if there's no contact information, which will either delay your case or at worst, it's going to result in a denial because they're not going to be able to fully adjudicate or confirm the details of your case. Another challenge can be a package that's too large, too involved. If you're going beyond the core details needed with your offer letter, your TN employment letter, your education documents, things like that are the core elements of your TN package. Sometimes the more you include isn't always the better for this kind of case. They only have a few minutes to review your packet, and if they can't find those critical elements, they're also going to run out of time and may deny your case just for lack of time. Another challenge that a lot of workers face is not being consistent, not being familiar with the offer. So know what your employer does, know what your job duties are. Just be familiar with that offer letter so you also know where you're going to work and how much you're going to be paid. So all of those are very common details that an applicant may not remember off the top of their head, but it's all right there in black and white for the officer on the offer letter. But some officers will lean heavily on the applicant to provide that information without even opening the packet. So knowing that information and being consistent with what is in the application, and say in case they decide to open it after you've already had the discussion, that's, those are very basic things that you can make sure you don't have an issue with that can make or break your application. The last most common issue is, when the officer starts asking about your intent, what do you plan to do after the visa? Be very clear that you plan, it's a non-immigrant visa type. You make clear that your intent is to return to your home country after you've finished your contract. That doesn't preclude you from being able to file an extension for your TN. You know, that question being so open-ended can cause some confusion for applicants, where they may say, oh no, I want to work in the US forever, I'm going to keep extending my TN. That's not the right answer. Your answer is, your job offer is for 2 or 3 years, whatever is in your employment letter, and you plan to return home. You have no intent to stay permanently in the US. You have no immigrant intent. That's what they're looking for. And if you answer in a way that's a little confusing for the officer, that also can make or break your application.
That was interesting, and thank you for that insight. Now let's talk about long term. What are the work eligibility considerations for T1 and L1, sorry, TN and L1 visa holders, and how can they plan if their goal is to be permanent residents?
Sure. So a big difference between the TN and the L1 categories are the timelines and the validity periods for the visas. A TN is going to be, based on, depending on your employer offer letter, but the initial visa will be issued for up to 3 years, and then there's no limit to the number of extensions, or, even if you switch employers, you go get a new TN, there's not a cap on your TN time. For the L1, that's not the case. L1Bs are issued, they're both issued for an initial period of 3 years, but the L1B is capped at 5 years and the L1A is capped at 7 years. So, you have to return to your home country or switch visa types, classifications after those periods. You'll run out of time. Now, as far as long-term planning for like a green card, a TN is not a dual intent visa, meaning it requires a lot more strategic planning when either filing for a permit application or whatever other kind of green card category you may be eligible for, and looking at what those processing timelines are. How long is are you going to be able to adjust status while you're on your current TN? Are you going to run out of time and be faced with inability to renew your TN because your green card process has already been approved or filed, but you've not been able to take that last step? So it does require a lot more strategic planning if you're on a TN, and some people on TNs may pursue an H-1B, trying to get in the H-1B lottery to try and have a dual intent visa, and because that will kind of take away that mitigate that risk, because you will no longer be trying to pursue an immigrant visa while on a non-immigrant visa. And there's where an L1 will become beneficial for a long-term plan as well, because L1s are dual intent, so you can pursue both avenues concurrently, without an issue of being questioned for immigrant intent. Now, that being said, with an L1, you still may not be able to process in time before you run out of L1 time, and an H-1B or something like that would still be beneficial to you. That's just going to be a very case-specific consideration, but those are kind of that's kind of the core of planning for between those kind of cases for long-term residency.
All right, thank you. Regarding L1 visas, could you elaborate the key differences between an L1A and an L1B categories, and how someone can tell which category best fits their case?
Right. So while they're both categorized as an L1, they have the same, alphabet for their visa classification. It's there are very different ways to show qualifying for each one of those. For both categories, a commonality is the worker needs to have been employed at a foreign entity for at least 1 year in the last 3 years in order to qualify, and they need to be transferring to a US-based entity that is related in some way. They share a parent company, they're a subsidiary. As long as they meet that, relationship between the two entities, then that would qualify. That's going to be the same regardless of category. But beyond that, you kind of get into where they're very different. An L1A is focusing on an executive or a managerial role. So you would have been performing either as a functional manager, meaning you're leading some important project or function within the organization, or maybe a whole department of some sort, but you don't have people management duties. You're, a functional manager in some way. And alternatively, you could be a people manager. Maybe you're able to look at an org chart, and you're here and you have reports, direct reports or indirect reports underneath your umbrella. So that's where a manager, that's what an L1A. It's very going to that org chart, or is going to be critical to the case, either showing people management or showing where you're managing a function, and where those projects will flow down, and getting into things like that. Now, L1B is focused more on your expertise. So it's a specialized knowledge unique to the company that you've been working for abroad that is, needs to be transferred to the US. So it's something regarding products, processes, specialized technology or intellectual property, something that is very unique to the company that they could not find hiring someone with a similar, education and background off the streets that can't just jump in and start doing that job. So, one is very much focused on the skills and knowledge that someone possesses, and the other one is very much focused on some sort of managerial aspect, whether that be a function or people, a team. So, that they're both, there are some commonalities, but the applications and qualifications are very different. Now, L1A also has an alternative pathway to a green card, because you can file for EB1C, which is a multinational manager or executive, but on the green card side. So a lot of the supporting documentations and eligibility are going to be overlapping, if not identical. So if you're able to work here on an L1A, that's a much shorter pathway to a green card than having to undergo the perm labor certification process that you would have to undergo for L1B. So, that's something that is a little bit different between the two. They still are both dual intent, but being a manager, there's a little bit more of a streamlined pathway for that. So those are the primary, very high level differences, but determining the right category really is just going to come down to, talking to your managers, looking at your job description, looking at your duties, and determining, what is going to be the closest fit. It doesn't end up, in most cases, being a particularly difficult analysis to see which is going to apply. Some of the functional manager L1As that are kind of on the margins may be able to be one or the other, really. Like, you may have specialized knowledge, but you manage a function. And functional managers can be a little more cumbersome to get through USCIS, because they're a little more subjective, right? Because it's not something where USCIS can look at an org chart and say, okay, of course, you're managing people, you're managing a team. It's a lot easier for them to kind of check that box than kind of have it analyze whether or not you're actually managing a function that they may or may not understand. The officer may not be technical enough to understand what you're actually doing to see that it's a true functional role.
That's good to know. And what about the business side of things? In your experience, what are the necessary components for a successful L1 visa application, especially when a company is setting up a new office in the US?
Right. So there's lots of things for an L1 that are going to be, like I said, same across the board. A successful application will be, we'll need org charts, manager letters describing your position abroad and in the your intended position in the US. And that'll be a very detailed, job description that's included, regardless of whether you're a manager, L1A or B, like breaking down the percentages and subcategories of your duties to really examine your role at a very granular level. You'll also have 1 year of pay stubs with the company abroad, that not as a contractor. It needs, you need to be an employee. That's a very key element. Evidence of the relationships between the U.S. and foreign entities to prove that it's a qualifying L1 relationship. That's going to be critical. If you're applying for specialized knowledge, you're going to need evidence of that specialized knowledge, maybe project samples, whatever you can get that you're able to redact, but still get enough the substance to see that it's the core nature of your specialized knowledge. So performance reviews, if you're filing as a manager, those are very important. Now, if you're looking to establish a new office, and that's an important distinction also as far as the timelines. If you're establishing a new office, the initial L1 is only going to be valid for a year because they'll essentially reevaluate after that first year to ensure that you're now operating in the U.S. And doing everything that you said you were going to be doing in your initial application. So for a new office, you'll obviously establish all the documentation that I just talked about, but also a successful application may have a detailed business plan, revenue projections, things like that to show that you do have plans to operate, you have a viable business, maybe you already have contracts or sales pipeline set up, depending on what the nature of your business, and you'll have evidence of the foreign company's financial wherewithal in order to support this new office while it's getting off the ground, because initially this office isn't going to have income. So a brand new office will need to, that's a unique requirement that for a new office is that, establishing that the foreign entity can support that new business while it's getting off the ground. Another kind of outdated requirement for a new office is that they have a physical space. So you'll need a leased office space, a dedicated space. Again, with some businesses that are operating with remote work and mobile, workforces being so common, that doesn't seem like a realistic requirement for some companies, but as far as the L1 is concerned, it is a cost consideration for a company starting a new office under an L1, because that would be something that they may not otherwise have as a business expense if they were not establishing the office as an L1. It's just or just say, I just wanted to start a business. Maybe I want to do it remotely. They don't really have that option. So there's some additional overhead involved with a new office that you may not have expected. And that can be something I talk with clients that they weren't expecting to have to incur that expense because maybe they're already a globally distributed workforce and they don't maintain a core headquarters in person anywhere. So that's, a foreign concept, especially in this day and age.
Totally understandable. To our amazing audience, thank you for joining us. Whether you're tuned in from Facebook, YouTube, or LinkedIn, we're honored to have you here. We are immigrationquestion.com, a platform built to simplify the immigration process. You can ask your immigration questions for free in any language and get connected with a verified attorney for guidance. You may also receive a free confidential initial consultation. Just visit www.immigrationquestion.com and sign up today. Now, Attorney Kirchner, a platform that connects documented and undocumented immigrants with trusted attorneys like yourself. What are your thoughts about how immigrationquestion.com supports the immigrant community today?
Sure. In this day and age, especially with this new administration, remaining abreast of new developments that are constantly coming down the pipeline is critical. And an experienced attorney will have multiple avenues that they're exploring for ensuring that they're up to date on all of these changes, whether they're executive orders, formal policy changes, policy adjudication manual changes, maybe just trends in adjudication patterns that aren't related to anything that's been written down or issued by the government. Those are critical data points that these attorneys are going to be following. So, with the platform connecting people with these experts, that gives them an opportunity to, tap into that knowledge, tap into those resources so they don't miss something with their case or their immigration status or their plans. So it's a great service for people to, prevent errors or mistakes or consequences that could have otherwise been avoided if they had consulted an expert. So it's a great way for people to kind of avoid some of those less than ideal situations that are arising, especially with the current changes.
Definitely. Thank you for that. And before we open the floor for our live Q&A session, just one last question. Are there any lesser known visa categories that professionals should consider as alternatives to the H-1B, T-1, or L-1 visas, especially when those traditional routes hit a dead end?
Sure. There's certainly other visa types that may be appropriate for certain individuals. They're going to tend to be a little more specialized or a little more maybe not specialized in the sense that they require more experience or more degrees, but just may fit a more unique or specific use case. O1 is one that is possible for individuals with extraordinary abilities in science, arts, education, athletics, or business, and maybe an alternative for seasoned professionals that don't quite qualify for filing an EB1, but they are extraordinary in their own right. That's a way that they can pursue something other than an H1B or an L1. J1 is something as well that's possible, but those do have more restrictions as far as the type of positions, the type of your age requirements, education requirements. But those kind of training programs may work well for someone who is still in school or otherwise meets those eligibility requirements. Another possibility is E1 or E2 treaty investor visas, but those, are going to be limited to certain countries and are going to require, financial wherewithal. Those are going to require some sort of investment on the part of the foreign national. So there are lots of those can be a good fit for a good alternative to like an L1 new office, something like that. Now, some positions for H1B, like accountants or admin professionals, there are possibilities for like H2. That's a temporary seasonal visa, or a one-time need, like for a nanny. That could be an alternative, for a care professional. So it doesn't necessarily require a degree. It would be very case specific to the type of job that is seasonal or peak load that falls into. So it may not serve so many of the L1, but it could be an alternative for some TNs or some H1Bs. But again, that's going to be highly reliant on the company that's sponsoring you to be able to meet those temporary requirements. Those are the most common ones. There's, again, an alphabet soup of visas available out there, but those are the most common alternatives to those particular visas.
Thank you. To our audience, the floor is now open. Drop your question in the chat and we'll answer as many as possible. If you'd like to call us live and ask directly, dial 516-703-3483. All right. That wraps up the main part of today's session. And let's see the questions. So first question is from Mabel. Since there are some changes in the visa interview waiver eligibility, should applicants start to expect compulsory interviews?
Yes, with changes to those eligibility, it's going to be more common for applicants to need to have an interview at the consulate. And that also is going to result in possibly result in further consular delays or backlogs for interview dates, because those are, if they're getting rid of a large portion of the people who would otherwise qualify for a waiver, maybe last year or just a few months ago, they're going to have the same amount of people on staff, same amount of officers. So, but more people having to actually go in person to get in front of an officer. So there's only finite time and resources available at the consulate. So absolutely expect some ramifications from that.
Next question is, what are the good visa options for workers from countries like Nigeria that want employment in the U.S. this year or next?
A lot of visa types have not been limited by particular countries. It's going to depend on either the employer and what kind of work they do, or the employee and what experience, skills, education that you have available. That'll really dictate what the best visa option is going to be for you. There's not going to be any options that are particularly streamlined or particularly fast. H1B requires the lottery, and then you have to get lucky enough to get selected. If you're looking at H2 work, those also operate on a numerical limit. It's not, they have a cap. So there's certain ways that those are limited. So it really is going to be a case by case for you. There's not going to be one that's just as simple as where you're from necessarily. It's going to be be able to give an answer.
That's understandable. Next question is, has new policy changes affected processing time and approval rate for L1 visa applications?
Thus far, the processing times have not changed tremendously, but we are very early on in the process. I don't, you've seen on the news staffing cuts, reductions, and resources, contractors. The return to work, directive is going to result in, again, further staffing reductions because there's, many people are so dispersed now they can't return to the office. So it's expected that these processing times aren't going to get any better. It's really too early to tell to see how much of an impact they're going to have. Same thing at the consulate. We talked a minute ago about the waivers. So, having more limited resources or appointments available because there's so many more people needing to be in person, that absolutely can impact the times. Again, to date, it's a lot of these things are so fresh that they haven't had a tremendous impact yet, but it is certainly within the realm of possibility for it to backlog or have significant delays based on some of these changes.
Understandable. Next question is, I am a Mexican citizen and I hear that they've increased TN visa denial for Mexico. Should I still apply?
That kind of plays into the first question that we talked about. Denials certainly have gone up. It's not unique to Mexico. There've been an increased possibility of denial on the northern border as well. Really, they're just trying to. A lot of the denials are stemming from poorly written letters or positions that maybe are on the margin. Maybe they are more manufacturing or assembly line kind of case positions that aren't true engineering positions. I know we're not talking about any particular occupation, but I know there's been trends, for those kinds of industries where there's some pushback. They're trying to tighten down the eligibility and make sure that you're staying true to the occupation that you're applying for. So that's where kind of being prepared with a proper packet, a well-defined job description, and offer letter is going to be critical. I wouldn't say that you shouldn't apply because of anything that's happening right now. I wouldn't make such a blanket statement based on the current situation, but it is very important to make sure you're doing everything you can to have a complete, streamlined application that is very clear and easy for the officer to understand.
Thank you. Next question we have is, I have a master's degree from an American university. Will I be given an advantage in the H-1B lottery?
Yes, that will, if you have a U.S. master's degree, you would be eligible for the master's cap. You would be the primary lottery as well as the master's cap lottery. So that would increase odds. I don't have a percentage as to how much it would increase your odds, but it certainly does give you somewhat of an advantage.
All right. And then I heard the H-1B registration fee increased from $10 to $215. Is the government trying to make it hard for small companies to sponsor?
It's not designed to make it more difficult for small companies to sponsor. It may have that impact. However, it's still a relatively nominal fee for if you're just sponsoring one worker or two workers, which most small companies wouldn't be doing any more than that. So the burden, while definitely more expensive and as a percentage basis, a tremendous increase, it's not really meant as a deterrent for small employers. Really what it's meant to be is a deterrent for fraudulent applications. So if the fee is only $10, more companies were filing duplicative applications or on fraudulent applications for various other companies, and a lot of that the investigations of fraud that they have had come down the pipeline in the past year is kind of stemming from all of those extra applications that have been filed. So the thought process was that if they increase the fee, people will be less likely to spend extra money on additional applications. So it's not really meant as a deterrent specifically for small businesses.
So that was our last question. So this wraps up today's session. Thank you so much for joining us, and a special thank you to our guest, Attorney Meagan Kirchner, for your practical and strategic insights. We hope the webinar helped demystify your work visa options for 2025 and beyond. Don't forget you can rewatch this session or listen to the previous episodes on Spotify. Just search for Borderless Talk by immigrationquestion.com. Join us again on Friday for another timely discussion on U.S. immigration pathways. Trust us, you won't want to miss it. Once again, thank you, Attorney Kirchner, and we look forward to having you back soon.
Thank you for having me.
Thank you.